Before 24 February 2022, i.e. before the invasion of Ukraine by Russian Federation troops, 373,000 Ukrainians were working on Polish construction sites. The war made many of them leave Poland. They went to Ukraine to bring their families to Poland, or to look after them in Ukraine, or to fight to defend their country. These absences cause delays in the performance of construction contracts. The second factor that causes problems in the performance of contracts are difficulties in import, or the complete impossibility of importing some raw materials and components from Ukraine, Russia and Belarus. This applies to steel products and parts for the production of cars. It will take some time for existing suppliers to be replaced, resulting in delays in fulfillment of orders. The war also causes crazy increases in the prices of building materials and raw materials. They could not be included in the calculation of the remuneration for the performance of contracts. Therefore, at present, it is of particular importance to be able to invoke war and economic sanctions as cases of force majeure. This issue will be discussed in a moment by my guest, Mirela Lechna-Marchewka, attorney at law who heads in Wardyński and Partners the practices of infrastructure and public procurement. Welcome to the program News from Poland, Business and Law, addressed to foreigners acting as board members in Polish companies, foreign investors in Poland and their foreign advisors.
Lawyers draft contracts for difficult times, even though certain clauses may relate to very unlikely circumstances. 2 weeks ago, war was merely a threat, and as an act of force majeure, it was usually a matter for a university seminar. Unfortunately, current reality requires continuous crisis management. 2 years of successive waves of rising COVID-19 infections may have hardened contractors of public procurement contracts, but war was not a factor that any had accounted for in their bids. The war has affected not only residents in the battle zones, but has also caused an immediate rush of Ukrainians from abroad to fight for their homeland. One aspect has been the interruption of contracts in Poland on which Ukrainians were working. Other aspects have included disruption in production and services because of the loss of Ukrainian subcontractors and supply chains, or involvement of Poles in supplying aid. An indirect aspect is a Russian factor disturbing the performance of contracts. Sanctions have been imposed on Russia, which could directly or indirectly affect the performance of other contracts. The war is dramatic, and the effects on public and ongoing contracts could be severe. The liabilities of contractors will depend on the facts and the contractual terms. The notion of force majeure is not defined in the Polish law, but its commercial practice definition appears in most contracts under public procurement law. War, in its factual sense, is a usual instance of force majeure and includes military operations in general, invasion, terrorism, mobilization, and embargoes. The war in Ukraine falls within this category because this is an event that is external, was impossible or nearly impossible to foresee, and it could not have been prevented by the parties. An event of force majeure can occur anywhere. It must merely affect the performance of the contract. One of the effects of globalization is that the performance of a contract under Polish law in Poland can be affected by factors outside Poland. If the war in Ukraine continues, it could be a force majeure event in Poland if it disrupts the performance of the Polish contract, such as though a sudden outflow of labor, a sudden increase of the cost of fuel and other key raw materials, a sudden shortage of raw materials or goods. The war in Ukraine may also affect contractors carrying out contracts in Poland, also in the territories of other states, if the supplies come from there or elements of the contracts are performed there. For instance, if the sanctions on Russia make it impossible to fulfill deliveries at present. Force majeure occurs when an event affects the performance of a contract. The deadlines for notifying force majeure are important because failure to keep a deadline often means forfeiture of the right to rely on force majeure. One should note that it is not necessary to obtain a certificate confirming the occurrence of force majeure in Ukraine, while it is also not sufficient for a successful invocation of the force majeure, similar as the situation under the pandemic. If there are contractual penalties for failure to complete work, services or supplies on time, a contractor that is in default because of the war will avoid liability due to their lack of culpability. However, the contractor would have to prove that the war caused a full or partial default. If a contract lacks a force majeure clause, the general rule under Article 471 of the Polish Civil Code states that liability for failure to perform a contractual obligation exists only if it is a consequence of circumstances for which the contractor was responsible. Therefore, force majeure may apply even if not expressly provided for in the contract. Apart from the issue of liability for failure to perform a contract, the war could necessitate the amendment of the public procurement contract. However, the parties would have to agree to it. A method for adjusting public procurement contracts for pandemic-related reasons appeared in the Special COVID Act. Even though similar legislation is unlikely, Article 15R of that Act could serve as a guide for contracting authorities on how to amend a contract due to the impact of the war in Ukraine. The contractual right of withdrawal from a contract due to the extended situation of force majeure is not excluded this time. Therefore, it is in public interest to proceed with these changes quickly so that the public contracts may be performed despite the obstacles.
Thank you for watching. See you soon.